Okay, so we are going to go ahead and get started. It is 12 o'clock. Before we officially get started, we are providing Spanish language interpretation for this webinar. So before we begin, I would like to give the interpreters a moment to provide the instructions to access the Spanish language interpretation. Angie?
Sure. Thank you, Chrissy. Yes, good afternoon. My name is Angelina, and I'm here together with Felipe with Full Circle Interpreting. We're providing interpretation from English to Spanish today. So please bear with us for 1 second while we make an announcement in Spanish about how folks can connect to interpretation. Thank you. Hola, bienvenidos a todos. Estamos ofreciendo interpretación el día de hoy, así que por favor seleccione su canal de preferencia. La forma de seleccionar español es que en sus controles de Zoom aparece un símbolo redondo de un mundo. Presionen ese botoncito redondo y luego se van a ir a español. Si están utilizando un teléfono o una tableta, esta opción está ubicada abajo a mano derecha. Van a ver 3 puntitos. Presionen los 3 puntitos, eso les va a abrir más opciones. Luego se van a interpretación de idioma o language interpretation. Luego seleccionan español y luego ponen el botón que dice done para poder escuchar. Les recordamos que la función de interpretación no funciona en Chromebooks, así que por favor procuren conectar con un computador o un teléfono inteligente. Cualquier pregunta que tengan nos dejan saber en el chat. También si nos quieren dar un saludito en el chat para confirmar que todo se está escuchando bien en español sería genial. Gracias, que tengan una buena sesión. Okay, I've made the announcement in Spanish. I'm going to go ahead and post this in the chat as well for folks to have, and let us know if you need us to announce it again later on. Thank you. Back to you.
Wonderful. Thank you so much, Angie. Thank you. Okay, so now we're going to officially get started. Hello, everyone. Thank you so much for joining us for a guide to guardianship. My name is Christy Moore, and I am the Family to Family Health Information Center program lead with the Exceptional Children's Assistance Center. That is such a mouthful, never gets shorter. As I mentioned before, we are recording today's webinar, so everyone will get a link to the recording as well as a PDF of the slides and a certificate of participation and a follow-up email. And that'll go out. I'm not gonna promise today. I'm gonna shoot for today, but if not, that will come out early next week. Our presenters today are Emma Allison and Evelyn Blanco, JD candidates, class of 2023 at Duke Law. And I just want to say that we really, really value our partnership with Crystal Grant and all the folks over there at the Duke Children's Law Clinic. I'm going to take a quick minute just to read our disclaimer, and then we can get started. ECAC is providing this webinar as a public service. Reference to any specific product or entity does not constitute an endorsement or recommendation by ECAC. The views expressed by guest speakers are their own, and their appearance in a hosted webinar does not imply an endorsement of them or any entity they represent. Views, thoughts, and opinions expressed by presenters are their own and do not necessarily reflect the view of ECAC or any of its staff. I do want to say that we welcome your questions, and we hope you have a ton of them. And I usually ask people to put questions in the Q&A. However, this time I am going to ask that you put them in the chat. And the reason for this is if there are any questions, these two women have done such a great job writing and doing all the research for this presentation. But if there are any questions that they or we cannot answer today, what we're going to do is we are able to save the chat where we're not able to save the Q&A. So we can save your questions and questions that we were not able to answer. We can then do some research and send a follow-up document with answers to those questions. So please put questions in the chat. Thank you very much. Okay. And with that, I would like to turn it over to Emma and Evelyn.
Thank you, Christy. Hello, everyone. My name is Emma Allison. I'm going to reiterate or restate some of the things Christy said. But my name is Emma Allison. I am a JD candidate at Duke Law in my 3rd year, so graduating in May. With me is Evelyn Blanco, who is also a JD candidate at Duke Law, also in her 3rd year and graduating in May. We are working with the Duke Children's Law Clinic, and in that clinic are under the supervision of Crystal Grant and Peggy Nicholson. So this presentation today is meant to give a very broad overview of guardianship, when it can be useful, and how to pursue it. Like Christy said, if you have questions, please put them in the chat and we will answer as many of them as we can. If there is anything that we are unable to answer today, we will do some research afterwards. And like Christy said, the email can be sent out later trying to answer any questions that got missed. So I can begin. My computer will work. Okay, so this is just a brief overview of what the agenda is going to look like, so you have an idea of where we're going. So we'll start off with just a basic explanation of what guardianship is, and then we'll go to some common reasons for seeking guardianship, then some common questions about the rights under guardianship for the person under the guardianship. Then we'll talk about the process for obtaining, modifying, and terminating a guardianship, and then we'll look at some alternatives for if you don't want guardianship, but you still want something there. And then afterwards, we'll get to the question and answer session. So broadly, in North Carolina, guardianship is defined as a legal relationship in which a persons or agency who is the guardian is appointed by the court to make decisions and act on behalf of another person who is the ward, who does not have adequate capacity to make decisions involving the management of personal affairs, property, or both. It may be defined differently in other states, but that's what it is in North Carolina. And then there's 3 types of guardianship, which we will go through more specifically later in the presentation. But for now, there are general guardianships, guardians of the person, and guardians of the estate. So who can be a guardian? It is an individual or a corporation who a clerk appoints. This is somebody who is considered competent and is over the age of 18. Briefly, also, the term guardian is a legal term that we use to describe the person who will be in charge of the ward. And then similarly, the term ward is a legal term that we use to describe the person who is under the guardianship. For the purposes of this presentation, we may use the term ward, we may say the person under the guardianship, or we may say individual, just to maintain a person-focused mentality, excuse me. So a guardian can be a family member, a friend, or a public guardian. There are services that provide guardians for those who don't have a friend or family member who can be a guardian. It often will be a parent, but in some cases, another individual may be better suited. Many people prefer for it to be a family member because there's a high level of trust needed. But who the best guardian will be will depend entirely on the specific situation of each person, which is going to be a running theme throughout this. Every person's situation is different, and what factors into the decision is different for everybody. A guardian will be appointed bearing in mind what is in the best interest of the person who will be under the guardianship. Like I said, it varies from situation to situation, but the decision of who the guardian will be should be weighed very carefully, again, because of that very high level of trust and because of the level of control they will have over the person under the guardianship. According to statute, there is an order of priority that the clerk has to follow. So when considering appointing a guardian, they will first look at an individual who is recommended, who the family would prefer generally, another individual, and then a corporation, or lastly, a disinterested public agent. If a guardian is not a North Carolina resident, they must submit to the jurisdiction of North Carolina courts. And a corporation can only be a guardian if it is permitted to by its charter. So if it's in kind of the foundation of the company. And it cannot be appointed, a corporation cannot be appointed a guardian if it provides mental health or other specialized services to the individual who will be under the guardianship. So then on the other side of that, who is the ward? Again, we may use the term ward, but also if we're saying an individual under a guardianship or just an individual, this is generally who we'll be talking about. So it may be a young adult, it may be somebody who's a little bit older, but once somebody reaches the age of 18, they become a legal adult and have the right to make their decisions for themselves. Their parents no longer have the power automatically to make their legal decisions. If a person may struggle to make decisions for themselves, legal decisions, medical decisions, if they may struggle to access their own medical care or advocate for themselves, then it may be worthwhile to consider a guardianship. Again, the decision will vary from person to person, and it should be based on the circumstances, including the person's strengths, their weaknesses, and what's in their best interest. We'll discuss later some more of the specific reasons for pursuing a guardianship, but just bear in mind that it can be very different depending on the person.
Hi, so there are 3 types of guardianships, as we had mentioned before. The first one is the guardian of the person, and this is when someone is responsible for the care, the comfort, and the maintenance of the person under the guardianship or the ward. The guardian is responsible for the person's personal affects, so like your personal items, I don't know, your computer, your phone, etc., as well as for the ward's training, education, employment, rehabilitation, or habilitation. So in essence, the guardianship of the person is when a guardian is appointed to perform the duties relating to care, custody, and control of the ward or the individual under the guardianship. The second type of guardian is the guardian of the estate, and that is when an individual is appointed to manage the ward's property, estate, and business affairs. So this could be real property like buildings, office buildings, houses, etc., or their business affairs, which is, for example, collecting debts that are owed to the ward. So if for some reason they want a civil suit or something, it would be trying to collect those types of debts and monies that are owed to them. And then there is the general guardian, which is a combination of both the guardian of the person and the guardian of the state. And all of these types of guardianships may exist as limited guardianships. And that's our next topic. So limited guardianships can exist. You can have a limited guardianship of the estate, a limited guardianship of the person, or a limited general guardianship. And what limited guardianships are is a guardianship where a person under the guardianship retains some rights that they would otherwise lose in a full guardianship. And the North Carolina statute does encourage the use of limited guardianships where possible. It does instruct the clerk to consider limited guardianships when presented with a guardianship petition. And an example of a limited, we're going to go into the rights that the individual under the guardianship would typically lose. But for example, a limited guardianship could be where an individual with a developmental disability or mental disability does not require assistance with all decisions, such as choosing a caregiver or where they will live, but does require assistance managing complex affairs. So that type of person would not have possibly would not get a full guardianship, but might have a limited guardianship for handling those complex affairs. Again, we're kind of being broad in describing these topics because it varies in every situation, but for those people who might need assistance in complex affairs, a limited guardianship might be more appropriate depending on the circumstances. So we've covered the concept of a guardianship kind of at a high level. What is a guardianship? What types of guardianships are there? Who is the guardian? Who is a ward? But now we're going to get into the steps a little bit more. So the steps to create a guardianship in broad overview is one, you need to first file a petition with the clerk. And this petition can be found online or obtained in person at at a state court. And the petition does not need to specifically recommend a guardian. So it can just say I believe this individual needs a guardian, but you do not have to say who that guardian should be. Again, preference can be given to who you recommend if you do recommend someone, but you do not have to. Then secondly, you need to have certain types of information in the petition that you file so that the petition is valid. That petition needs to contain some types of demographic information about the person that you're recommending should have a guardianship, like their age, who they are, where they live, etc. So basic demographic information. But it also needs to explain the reasons why you're filing the petition and asking for the guardianship. So, for example, listing any mental disabilities, medical conditions, anything else that might be relevant to the clerk to consider on why the guardianship is being sought. Then you do need to submit the fee along with the petition. A fee along with the petition, and that is a filing fee of $120 and a sheriff's fee of $30. So it is $150 total, $120 plus $30. And when you file the petition and fill it out to the clerk will process it, and this will trigger a hearing to determine if the individual that you recommended needs a guardianship, does need a guardianship or not. And within 5 days of you filing the petition to the clerk should send out a notice about the details of the hearing. So where will it take place? When will it be? And typically those hearings are scheduled for 10 to 30 days after the clerk serves that notice. So file a petition, wait 5 days, clerk gives a notice, and then from that time on, within 10 to 30 days of that notice, the hearing should be scheduled around. And the individual who is recommended to be placed under a guardianship is entitled to an attorney. If they can either get an attorney appointed as a guardian ad litem. So that means like a attorney that is provided by the court, the government, or you can retain your own counsel, but that will cost money. So if you choose to, say, retain an attorney that you've worked with in the past to defend or to show your rights in so this is for the, sorry, let me just clarify. This being entitled to an attorney is for the person who may be placed in the guardianship. So it would be the ward. That person can hire their own attorney with their own money, but they can also be given a attorney who would be appointed as a guardian ad litem and represent their interest. And their interest could be wanting the guardianship or fighting against the guardianship, depending on the circumstances. But that attorney would represent the individual to be placed under the guardianship's interests. And the person to be placed under the guardianship is also entitled to ask that their competency be determined by a trial by jury. And if they do not ask, then they lose that right. So the person who would be the ward under the guardianship can ask for a trial by jury, but they must do so or they waive that right.
So here are some common reasons to establish a guardianship. Many of them are very similar. But first, a minor who is almost 18 and would be considered an incompetent adult. And our next slide will be discussing what it means to be incompetent. Similarly, or not so similarly, a minor who loses their parents and may need a guardian to make legal decisions would be placed under a guardianship. This can also be for an adult who becomes incompetent well after the age of 18 due to an injury or illness. Again, a loved one of any age, so young or middle-aged or older, who is no longer mentally capable. A loved one, again, of any age who suffers from a significant mental illness, developmental disability, anything like that. or a loved one of any age who is severely disabled and unable to properly care for themselves. A guardianship may be useful to help care for them. So, what does incompetency mean? I first want to say that incompetency can be kind of a big, scary word to hear your loved one described as. In this case, it is a legal term and it is necessary for a guardianship, but it is not a medical term in this particular situation. But a person must be found to be incompetent in order to be placed under a guardianship. Broadly, incompetency is related to a person's ability to make financial and medical decisions for themselves, to communicate important things about themselves or their family, to advocate for their needs, or to take care of themselves on a day-to-day basis. Incompetency does not mean that someone is completely incompetent, and similarly, incompetency in one area does not mean incompetency in all areas of life, especially in situations where someone may only struggle with financial decisions or may only struggle with medical decisions or something like that. You could look at a limited guardianship or some of the alternatives we'll talk about later. If someone, like I said, may only struggle with one or two things and not all of these areas. And we will discuss now kind of how that legal finding of incompetency is determined.
So one of the tools that can be used to determine if there is legal incompetency is a multidisciplinary evaluation, an MDE. And this is an important tool that the clerk can use in determining incompetency, and not just if there is incompetency legally, but also what the scope of the guardianship should be if there is one. So if a limited guardianship is more appropriate, the MDE will help with this as well. So any party can request the MDE in writing. So it can be the person who petitioned for the guardianship. It can be the person who would be the ward. Both parties can request the MDE in writing, but the clerk can also decide to order an MDE on their own without either party asking for it. And the clerk will be the one that ultimately determines whether there is an MDE or not, even if it is requested. And once the clerk does order an MDE, they will designate an agency to prepare the MDE. And what this means is that the clerk is going to designate an agency, and an agency can be a state, local, regional, or otherwise close to the area, a mental health a provider, a social services provider, or a diagnostic center that typically helps with these MDEs. So that's what it means by appointing an agency to prepare the MDE. And the MDE will usually contain evaluations as well as recommendations regarding the appropriateness of guardianship. And the most common types of evaluations that it will contain are medical evaluations, psychological evaluations, and social worker evaluations. And the clerk may ask for other types as well. The statute is very flexible as to what types of evaluations can be asked for. But the most important thing is that the agency needs to present the evaluation to the clerk within 30 days. And the clerk can also order that the person who would be the ward, the person who would be under the guardianship, must be present for the MDE. So for example, sometimes a medical evaluation doesn't already exist, or it's necessary for the individual who might be placed under the guardianship to actually present in front of a doctor to conduct the medical evaluation. So that can be ordered by the clerk as well, that the person is actually presented, like physically present, to be evaluated. And importantly as well, the results of the MDE are not public record, so they would not be findable by the public, and they will not be released unless ordered by the clerk. So that means it is possible for someone to obtain the MDE documents, but they would have to go through a process and it would have to be allowed by the clerk to do so. But the people who are actually involved in the guardianship matter, so like the person who petitioned for the guardianship to happen and the person who would be placed under the guardianship, they will receive a copy. And so just in summary, very important that the MDE that is presented by the agency, it has to have two factors in it. It has to, one, set forth the nature and extent of the disabilities that are in question, if there are any. And it does that through providing evidence of these evaluations that occur. And then two, it needs to recommend a guardianship plan and a program. And that recommendation can also be no guardianship plan or program, or it could be a specific type that we've discussed, or it could be a limited guardianship plan and program. And then just lastly, paying for the MDE. I know that's a common question that can come up as well. So if who pays for the MDE is kind of determined on the status of the ward or the person who would be placed under the guardianship. So if that individual who would be placed under the guardianship is determined to be legally incompetent, but they are not indigent, as in they don't meet certain requirements of a certain economic level, like if they're not of low socioeconomic status, then that person who is deemed incompetent must pay. So if they are incompetent but not of a low socioeconomic status, then the person who is incompetent pays. If the person is incompetent legally but also is indigent, so of a low socioeconomic status, then DHHS pays, so a state agency pays. If the individual is not legally incompetent, then the clerk basically decides who pays. They can decide either that the person who petitioned pays, or that the person who would be placed under the guardianship pays. But very importantly, if the person is not incompetent legally and the clerk believes that the petition was malicious or unreasonable, then the person who asked for the MDE is the one who has to pay. So just a little bit briefly to discuss, we mentioned that a lot of types of evaluations can occur, but the most common are medical, psychological, and social work. So these are just a list of some of the factors that can be included under medical examination. It would be, for example, a physical examination, like your annual physical, could be neurological examination, could be some laboratory results like blood work, etc. It could be your medical history. So not only are the current individual's current medical statuses looked at, but also any history that they might have in case, for example, there's a recurring illness or something. What the prognosis is also important. So what the doctor thinks will be the effects of the medical condition in the future. So is this disability likely to disappear in a few years or a few weeks? Is this a temporary? Is this a lifelong illness, etc.? And so all that is in the overall evaluation of the medical portion. Psychological can be an intellectual assessment, such as an IQ test, can be a behavioral assessment, could be a personal interview as well. So an interview documenting if there's any potential behavioral issues or mental health concerns. And then also, interestingly, the social work evaluation is very broad. It can explain like the person's living situation, where do they live, who do they live with, what their employment history is, what their education is, their financial situation, how their interpersonal relationships are, do they what kinds of friends do they have, family members, etc. And this is all to make a profile and to determine legal incompetency if there is any. And it can also include, like I said, other types of evaluations from professionals in other disciplines. So not just these three. For example, if the person has ever had vocational rehab, occupational therapy, psychiatric assistance, speech and learning therapy, anything like that could be also an evaluation if it's relevant in that situation.
So to go over kind of some of the responsibilities of a guardian, again, the three types of guardianship will change what the responsibilities of the guardian are. Again, the guardian of person is responsible for care, custody, and control. So they will be responsible for determining where the ward will live, for giving consent or approval for medical treatments and psychological and other care. And when establishing residence, the guardian must give preference to in-state locations and should place the person under the guardianship in the least restrictive placement. So not, putting somebody in an intensive assisted living or something if they don't need that level of care or assistance in their day-to-day life. The guardian of estate is primarily responsible for property and business related things. So they have to manage the estate, which is the money and the property, and must do so in the best interest of the ward. The guardian generally, regardless of the type of guardianship, must always act in the best interest of the person under the guardianship. The guardian of estate is responsible for paying the ward's debts, property taxes, income taxes, and collecting any monies due to the ward's estate. So if they loan somebody money or something like that, collecting that. The guardian of estate, however, is not personally financially responsible for the person under the guardianship. They're not paying anything out of their own pocket. It's all within the ward's estate. And then the general guardian is responsible for both the responsibilities of the guardian of person and the responsibilities of the guardian of estate. So medical care, living arrangements, property, money, etc. So it's just everything. So for the rights under guardianship for the ward, again, a guardianship, is intended to replace the authority to make decisions for the person under the guardianship. A guardian will take over all of the major legal decision-making for the ward, and the person under the guardianship will no longer have the independent right to exercise legal decision-making for themselves. However, and this is a very important however, a guardian should always take into consideration what the ward wants and should always allow the person under the guardianship to make decisions for themselves when they're able to understand the decision and the consequences, weigh the necessary factors. So that is one of the biggest responsibilities of the guardian, is to also consider when the person under the guardianship is capable of making a decision and allowing them to do so. Also, a guardian can always ask the ward what they would prefer. However, the guardian does exercise final decision making based on what they think is in the best interest of the person under the guardianship. So if the person under the guardianship wants to make a decision, but the guardian thinks that it would not be in their best interest or would not be a good decision, they do not have to honor it. Again, I do want to note that the guardian is not responsible for the ward financially, nor are they liable for any of the ward's debts. They don't have that legal connection to them. And also by statute, so by law, there are several principles that are recognized and incorporated into a guardian's role. Guardianship should be considered only when less intrusive alternatives are not appropriate, and if it will give an individual a fuller capacity for exercising his or her rights. So there's a broad concept in law of trying to keep people in the least restrictive environment and giving them as much freedom as possible. Second, guardianship should seek to preserve opportunities for the individual to exercise rights that are consistent with his or her capabilities, allowing for the possibility of error to the same degree as is allowed to persons who are not incompetent. So this kind of goes to what incompetence is, and it's not just making bad decisions. Everybody makes bad decisions and has the right to make bad decisions. It is a step beyond that. And somebody under a guardianship should still be allowed to, make mistakes as any normal human would. And the third principle is a person under a guardianship should be involved in all decision making consistent with his or her capabilities. So again, really trying to keep somebody involved in their own decisions and not having the guardian just take over their life completely. So now we want to go through some of the rights that somebody under a guardianship retains when they are placed under a guardianship, and some of the rights that they lose or are modified. We have several slides on this, and it can be a little bit complex. So first, someone under a guardianship can get married as long as they understand the contract of marriage on the day of the marriage. So they must understand what the legal significance of marriage is and what that contract does. However, if that person did not understand marriage on the day of the marriage, that is later proven, the marriage is void, which means that it is not a legitimate marriage and has not ever been a legitimate marriage. So there's no need for divorce or there's no marital property, nothing like that. It is considered basically to have never existed. If the individual did, however, understand the contract of marriage on the date of the marriage, they cannot begin divorce proceedings, and their guardian cannot begin divorce proceedings. This is generally because you have kind of two people in charge of their legal decisions, and there's tension there with something like this. So if there is a situation for divorce, the only person who can file for divorce is the individual's spouse. Oh, but sorry, my notes. A guardian, a general guardian, or a guardian of a state may defend an incapacitated ward in a divorce proceeding instituted by the ward's spouse. So there can still be that legal relationship. But again, they cannot begin the divorce proceeding themselves. So if somebody under a guardianship has children, they do retain their parental rights, their guardianship over their own children, unless it is actively revoked by a civil action. Those under guardianships also retain the right to vote, and they may be assisted by poll workers if needed. Also, the DMV will be notified once a guardianship is in place and will often suspend the license. However, this can be appealed. So somebody under a guardianship does not mean that they can't drive. There just may be extra steps to get that right back.
So some additional rights under a guardianship is the right to create a will. I think I saw this one in the chat. So if the individual under the guardianship understands the core concepts of a will, so what does it mean to will my property away? Who is my next of kin? What is my property? Those types of things. Then the individual may have the capacity to execute a valid will, and it's possible that that it would be, a legally sound will. However, there is this presumption that a person under a guardianship lacks the capacity to execute a will, and the will is automatically contestable due to this. But the presumption is rebuttable. So this means if a person who is under a guardianship creates a will, someone else can come in and say, oh, that will's not valid because X, Y, and Z. And the presumption will be that, oh, it may be invalid, but you can rebut that with evidence. So you can show, no, this person really did have the capacity, they understood. And maybe a lawyer can say they understood because of conversations with me, or family member can say, yes, they understood X, Y, and Z, etc. And then the right to execute a power of attorney. So an individual under a guardianship is not permitted to execute a power of attorney once a guardianship is already established. We say it in that specific language because we will discuss power of attorney more in depth a little later. And there are some things to note about a power of attorney, but once the guardianship is actually established, the person under the guardianship, the ward, cannot execute a power of attorney. And then the right to own a firearm. So the individual under the guardianship does lose the right to own a firearm once the guardianship is established. And then if the unfortunate circumstance happens that the person under the guardianship is a victim of a crime, then as with any criminal matter, it's up to the state whether or not to bring charges. So nothing is different there. And the judge who is assigned to the criminal matter will be the one who determines whether or not the ward is capable of testifying. So for example, able to say, oh, this happened to me and I believe it was this person. That type of testimony would be up to the discretion or the decision of the judge. And then if the ward or the individual under the guardianship is the perpetrator of a crime, so they commit a crime, then they are entitled to all the same rights as another criminal defendant. And the guardian may notify the defense attorney that they're a guardian. I mean, that's advisable, but it's a may. The guardian does not have to say that they are the guardian. And they might want to advise the defense attorney that that the ward is given. They might want to notify the district attorney, so the person who's prosecuting or putting charges against the ward, and the court about the guardianship. But ultimately, it's up to the judge to decide if the individual under the guardianship is capable of proceeding to trial, and is capable of actually being criminally prosecuted under in a trial format. So all of that is up to the discretion of the judge. And then this is kind of our last slide on rights under a guardianship. So a civil suit, a person under a guardianship loses the right to start a civil suit or be served in a civil suit without their guardian. So if you're going to initiate a lawsuit against someone who is under a guardianship, then you would have to also serve their guardian. If the individual under the guardianship wants to sue someone else, then the guardian needs to be a part of that as well. And then right to counsel. For issues pertaining to the guardianship, I think we kind of discussed this a little. The individual is entitled to an attorney who would be appointed as a guardian ad litem, or they can seek their own attorney. And then rights to appeal any decision that happens under a guardianship. The person under the guardianship, so the ward, can appeal any decision to institute a guardianship. And also, there's just a few smaller or less frequently that come up rights that we wanted to discuss a little that aren't on this slide. And so as we kind of hinted at, the ward could retain the right to testify as a witness, and that could be in civil suits or in criminal suits. Then some rights that might be lost, and these are just the less frequently that come up, so that's why we didn't put them on there, but they do lose so the ward does lose the ability to serve on a state jury. So they would not be able to be on jury duty, for example. They would not be able to serve as a guardian for another incapacitated person. So we did mention parental rights stay unless they're revoked, but a ward cannot be a guardian for another, let's say, incapacitated adult. And importantly, the guardian cannot consent to sterilization of the ward without consent of a clerk. So that's a very important right that the ward maintains to their own bodily autonomy, is that the guardian cannot force a sterilization. They need to go through a proceeding if that were to occur, if that's a factor in that specific situation. And then lastly, a guardian is also limited in their authority to make a gift from the ward's estate. So let's say the individual under the guardianship, they have a good amount of money. Well, the guardian is not allowed to just give that money away, let's say, to their friends, or to even let's say the ward's friends, or someone that is deserving of the gift, because that needs to go through a process and has to be approved through a superior court judge. And that's certain types of gifts. So, let's say a big amount of large sums of money. Those types of gifts need to be authorized with the approval of a superior court judge. So there are some limitations on the guardian's ability to give money of the ward away like that.
So once a guardianship is established, it is possible to modify it. This can be done by filing a motion with the clerk, and it must be in the county court that put the guardianship in place. So it has to be the same county. But that motion can be filed by any interested party. Upon receiving the motion, the clerk will have a hearing to determine whether the modification is in the ward's best interest. A guardian can also resign as a guardian, and a new one may be appointed. If the modification is considered to be in the ward's best interest, it will be implemented. If it's not, the guardianship will remain the same. The guardian can also the clerk may also remove a guardian and appoint a new one if it is shown that the guardian has mismanaged the ward's estate, has stolen from the ward, breached a fiduciary duty, neglected to care for the ward and or their dependents. If there's a conflict of interest with the guardian, or if the guardian is not qualified to act as a guardian, or if they failed to provide the clerk with accountings of the estate. You can also, I saw this in the chat, you can also transfer a guardianship to another county or a state. To do so, you have to fill out a form and apply for the transfer, so it's not automatic, but you can do that if you are planning on moving. You just have to, again, it has to be with the county that put the guardianship in place, fill out that form and apply for the transfer to have it moved. But it is transferable, you don't have to apply all over again. Additionally, an ex parte order may be obtained from the clerk in emergency situations. So if there is immediate danger to the ward's physical safety or finances, let's say they're in the hospital and the guardian is unavailable, or some other terrible, let's say the guardian and the ward were in an accident or something like that, you can apply for an ex parte order, so that something will be done immediately. You won't have to go through the whole hearing process just to have that legal control or that legal power in emergency situations. But it is a pretty high standard for it to be that immediate danger. So you can't get an immediate change for minor things. It is also possible to end a guardianship completely, but this can be a very challenging process, and again, is also a very high standard. In order to end a guardianship, it must be shown that the person under the guardianship is competent, and there must be evidence provided that the guardianship itself is no longer needed, and that termination of the guardianship is in the individual's best interest. Like I said, big theme throughout this is we're always trying to do things that's going to be in the person under the guardianship in their best interest. This can also be a very complex process because there's often conflicting evidence. So there was a finding of incompetency to put the guardianship in place. So you have to have enough evidence to get over that, to show that there is a showing of competency now and that the guardianship is no longer needed.
So now we're going to discuss a few alternatives to guardianship. So for some families or some individuals, a guardianship might not seem necessarily appropriate or needed at the time, or there are also sometimes concerns about a public guardian being appointed if there are no family or friends that can provide be a guardian for the ward. So some people might want to at least hear about alternatives. So one very popular alternative is a power of attorney. So generally a power of attorney is established by a written document. It's a legal document that must be written, and it authorizes a person to represent or act on behalf of another individual. And one very important thing is that powers of attorney are flexible and can be tailored to an individual's specific needs. So this written document, there are some formats out there and templates, and it can be very cookie cutter if you want it to be, but it can also be very specialized and tailored to your needs. So the power of attorney is a legal tool that is usually created with the assistance of an attorney and certain powers of attorney. So there are different types of powers of attorneys actually require a special format. So it is advisable to probably speak with an attorney because, for example, a tax power of attorney, which is where one person is responsible for the taxes of another individual, like, filing them, collecting them, etc., has to follow format specified by the IRS. So some things like that make it advisable to speak to an attorney before doing a power of attorney. But the document generally just specifies what the purpose of the power of attorney is, and it appoints an agent, so the person who will make the decisions, to act or make decisions on the principal's behalf. So the document does need to, unlike the petition for a guardianship where it doesn't have to recommend someone, power of attorney must say who will be the person responsible for the principal. So it has to say John is responsible for Mary, etc. And then it also needs it can also be tailored to specific types of types of decision making. So it can be, oh, this power of attorney is only for medical decisions, or this power of attorney is only for property, finances, or, like I mentioned, taxes, or other things. But it can also be a general power of attorney as well. And we'll get into that a little later as well. The power of attorney, for it to be valid as a legal document, needs to be signed and acknowledged by the principal. So the principal is the person who would person who would be, for example, having the individual make decisions for them. So that person who would get the benefit of the agent needs to actually sign it. And if for some reason they cannot sign the document, then they need to have someone sign on their behalf that has authority to sign the document, and the principal needs to be conscious and in the present. So this wouldn't work, for example, if someone was in a coma or something like that, or unless that person had already given authority to another individual. So it's a little tricky, but just wanting to specify that there needs to be consent. Like, that's what it's ultimately getting to. It's ultimately getting to making sure that the principal gave consent for the power of attorney to exist. And so when does a power of attorney begin? Well, it can begin depending on what the power of attorney says. It can actually begin the second that the signatures, the ink dries on the signatures. It can take effect immediately. It can take effect on a specified dates. So sometimes a power of attorney can say, this will take effect in 2 weeks, which is April, 20th, etc. Or it can take effect when a certain event occurs. So, for example, the power of attorney can say this only takes effect if the principal is incapacitated. So, for example, if the principal goes into a coma or can no longer respond, or something like that. So it can also be contingent on an event. Really, as we mentioned, powers of attorneys are flexible, so it all is determined on the language that you put into the document. And so just a little bit more about the powers of attorney. Well, when does it end? In North Carolina, by default, all powers of attorneys are durable, meaning that they will remain in effect even if the principal becomes incapacitated. But you can include language in your power of attorney to change this. So as I said, you can say this power of attorney only begins when the principal is incapacitated, or you can say the opposite. You can say this power of attorney ends once the principal becomes incapacitated. As we said, it's very flexible. And when drafting the power of attorney, you must specify that the power of attorney will. Oh, sorry. You may specify that the power of attorney will terminate on a certain date or when an event occurs. So you can say this power of attorney will end on April 20th, or you can say this power of attorney will end when the principal dies. The principal revokes the power of attorney. The purpose of the power of attorney is accomplished, so it can be tailored to the needs of the situation. And so the responsibilities of the agent, the person who would be making the decisions, the agent must act in the principal's best interest. Again, just like in a guardianship, we're always worried about maintaining the best interest of anyone we're making decisions for, or anyone that you're making decisions for. And you must do so in good faith, and you must act within the scope of the power given to you by the power of attorney. So if the power of attorney says this is only for health decisions, you can't go off making financial decisions as well. And then what happens to the power of attorney if there is then a guardianship? Well, if the power of attorney was executed before the guardianship, then it remains in effect unless it is terminated by the court or the guardian. Now, there's a little caveat here, or a little exception here, or something I want to highlight, is that the guardian may revoke or amend a general power of attorney that was already executed. So let's say, it was a power of attorney to do all types of decisions, financial, medical, etc. Then the guardian can terminate it or change it. But a general guardian or guardian of the person may not revoke a healthcare power of attorney executed by the ward, but they can petition the court to do so. So if a power of attorney already existed, then the guardian cannot just get rid of the healthcare power of attorney specifically, but they can ask the court to do so. So it can still be revoked. It's just that a certain process has to be followed. And some very common types of power of attorneys are general ones, financial ones, healthcare ones, but it can be tailored to your specific needs.
So there are some other alternatives to guardianship other than power of attorney. One is supported decision making. This is basically where somebody makes their decisions by consulting with other trusted people like family, friends, or any professionals that they may work with. This is a practice that puts somebody with a disability or a medical condition at the center of decision making, gives them the control over their own decisions, but allows them to lean on other people to help make those decisions. Some states do have very specific laws about supported decision-making. North Carolina does not. This is also a practice that a lot of people engage in generally and don't necessarily have an agreement or a structure for it, but it can be useful to have formal documentation, to have an agreement written up about the boundaries, the roles, how the decision-making process will work for somebody who's engaging in supported decision-making, just to kind of help set those expectations for that process. And then some other alternatives, which we won't go quite into the same depth about, but we wanted to point out. The first is a joint bank account. If you have somebody who may really struggle with making financial decisions, or really just is fine with making decisions, but is really bad about remembering to pay their bills or something like that, you can co-sign to a bank account. This allows for you to set up automatic deposits and withdrawals for paying bills or things like that, and allows for financial assistance and monitoring, so you can see kind of what's coming in and leaving the bank account without having that same legal control over somebody's financial decisions. Another alternative is a representative payee. This is for somebody who's receiving governmental benefits such as SSI. In this case, a representative payee may receive the benefits and use them to pay for the person's needs, and then save any remainder on their behalf. Can't go out and spend it as you want, has to be saved for them, must be saved responsibly. I did see a question in the chat about this. I don't know if you have to reapply to be a representative payee after somebody reaches the age of majority, if they are not already. However, you do not need a guardianship to be a representative payee. This is a separate application, and does not require the same level of legal control as a guardianship does. And then a special needs trust. This is a trust that's designed for people with disabilities. It's used to help cover costs that aren't necessarily covered by government benefits. They can be really complex to set up, but they can help support somebody financially if they don't have the money themselves. They're commonly used to pay for medical bills, caretakers, transportation, things like that. And then my understanding, I think I saw a question in the chat about this as well. My understanding of if a special needs trust is set up before a guardianship, that's considered part of their property, their money, and so could be managed by somebody, either the guardian of a state or general guardian, somebody who has the financial legal decision-making powers. So may not be able to be managed by guardian of a person, since that's focused on the medical things. And then I did see lots of questions in the chat about other resources. These are the places that we pulled most of our research from. They have a lot of information about guardianship, when to consider guardianship, how to consider guardianship, what the process looks like. When the PowerPoint gets sent out, all of these should be linked if it transferred from our format into the PowerPoint presentation that'll be sent. If they're not linked, you can Google the name of the organization, but they do all have a lot of really wonderful resources, and at least a few of them have people who can help talk to you, answer questions, and may be able to provide some services with helping fill out forms, things like that, because it can be very complicated, a very complex process. So these are some really great organizations to look into for further information.
Great. And with that, we did want to open it up to question and answers. I did want to say one small thing, because I think I wasn't clear about it on the power of attorney, and I kind of saw it pop up. So one big limitation of a power of attorney document is that, and then I'll go straight to the question and answers, is that the person needs to have competency to be able to execute the power of attorney. So if there's a doubt that someone is already incompetent and is trying to execute a power of attorney, that might be a reason that they cannot pursue that avenue. But if a person is competent and executes the power of attorney and later becomes incompetent, a power of attorney might still still exists because a document was executed when the person was competent. So that's a big limitation, and I didn't mention that, and I wanted to make sure I clarified. But now with that, I'll give it to, looks like Christy popped up.
Thank you, Evelyn. And I am happy to go through the chat and pull out the questions and read them, or if you want to do it, it's completely up to you. Would you like me to read them?
Sure. Thank
Okay.
you.
All right, so I'm going to try to hit as many as I can in the time that we have left, which is a good amount of time. And again, if there's some questions in here, the reason why we had you guys put them in the chat and not the Q&A is because we can actually download and save the chat after the webinar is over. We can go through them, we can answer the questions that we couldn't answer live, and then we can send out a Q&A document that hopefully answers all the questions. Okay, so I think this is the first one. I apologize if it's not. First one is, what about guardianship after your child reaches 18?
So anybody can be under a guardianship. There's no age limit for who is under a guardianship. And I'm going to hit two birds with one stone, because I also saw a question about when to start applying for guardianship, and you can begin that application once somebody is 17 and a half, because this adult guardianship is only for those who have reached the age of majority, so 18 and over, but it can start at 17 and a half to start the process to get it in place by the 18th birthday. But beyond the age of 18, there's no limit. It can be used for somebody who's elderly and can't make decisions for themselves. You could place them under a guardianship to make those legal or medical decisions for them.
Thank you, Emma. Okay, next one is, I have been told there is a $150 charge to apply for guardianship through the family's local court magistrate. I think you guys spoke about this fee. Are there options for help for families that cannot afford this charge?
So yes, that's correct. That is the amount of the fee. In our research, we did not come up with any resources, but we're happy to look into that if there might be any out there.
Thank you. Okay, next one is, my son just turned 18 in March. Is it too late to apply now?
Absolutely not. Like I said, you can start applying at the age of 17 and a half, but anytime after that, you can begin the process to put a guardianship in place.
How many guardians are allowed?
That's something that we also did not come across. I did try to do a quick search, and it looks like there may be situations where co-guardianship is allowed, but there are cautions with that because of the legal decision-making process. But that is something that we are happy to do more research on and put in that Q&A document for later to give a more thorough answer than I just provided.
And the question after that is also on the same topic. So let's see. The guardianship documents can be difficult to understand. Are there people or agencies that can assist with completing guardianship forms?
So this is along the same vein as the $150 fee. We didn't come up with the specific resources, but we're happy to look into seeing if there's any agencies or organizations out there that will help with those things.
And some of the resources at the end of the PowerPoint may have services like that. Again, we didn't look into that specifically, but that would be where I would start to look for those services.
And I do know that the ARC of North Carolina and the Autism Society of North Carolina both have a lot of great resources and toolkits on guardianship, and potentially contacting. And I know we have some folks from the Autism Society and possibly the ARC too on today. So maybe contacting those organizations. And if they don't have anybody, I'm sure that they would know if such resources like that exist for sure. They're great resources on guardianship as well. With getting guardianship, does that also mean that I would be able to keep him under my health insurance despite age?
I do not know the answer to that question, but that is a great question, and we will definitely look into that one as well.
Okay. Put that one in our follow-up. What's the difference between power of attorney and guardianship? I think you guys may have covered that later on in the presentation. This was one kind of question close to the beginning. Let's see. I was under the impression that in our state, the attorney appointed a guardian ad litem. Sorry, let me start over. I was under the impression that in our state, the attorney appointed as guardian ad litem does not provide counsel or representation in the way in which retaining your own attorney does?
So it is true that retaining your own attorney is a different type of like it's still a attorney-client relationship, but it can provide you different things. But I did want to just clarify, I read under the statute that the guardian ad litem is supposed to help with representing the potential ward's interests. So they're supposed to make every reasonable effort to determine the ward's interests regarding the incompetency proceedings and any proposed guardianship, and they shall present those wishes to the clerk, and they shall help consider the possibility of limited guardianship, etc. So they are there to express the wishes of the person who might become a ward, but there's definitely possibly differences, and you can explore those by possibly speaking to an attorney if you're interested in seeking that.
Okay, thank you. Could you speak to the pros and cons of trial by judge versus trial by jury in guardianship cases?
So we didn't specifically delve into this topic. I would say that, pros and cons, like there's differences, and whether you see it as a pro or a con depends on you. Like a judge is one singular person, a jury is multiple people, a jury is lay people, a judge is a person who understands the law. So there's just differences between who a judge is and who a jury is. But we didn't specifically delve into this topic, and I'm happy to do so in case there might be like legal distinctions between the two, but really it comes up to what you think is a pro and a con in your situation.
Thank you. Another question about that fee. Is there any way to get that fee waived?
So we're happy to look into that as well when we do the resources on the fees.
Does guardianship have to be put in a will?
So you do not have to put guardianship in your will. However, if you are the guardian, putting it in your will to designate who will take over the guardianship after your passing can be really useful. If you don't designate who the follow-up guardian will be, another person can apply, or the clerk will appoint somebody, again, taking into consideration the best interest of the ward. But the will is going to be the best way to ensure that you get a decision over who the next guardian will be, but it's not required.
And that goes right into the next question. What happens when the guardian passes away? Do we need a second choice? So I guess also, is that something that has to be outlined in a will, or is there somewhere in the guardianship application process that can be appointed somehow?
We can do further research on it, but my understanding is if it's not in the will, there may be a way to assign the next guardian in the guardianship itself, but I think the will is the best way. Otherwise, I think it's going to come down to if somebody else applies to be the guardian, or what the clerk thinks is best. But if a guardian passes away, it doesn't just end the guardianship. There will be a subsequent guardian put into place.
Thank you. Next question is, how do we request an MDE? Is it a form? And when do we submit the MDE? With the petition?
So an MDE, you would request that separately from the petition. I don't think there's a rule as to whether you file it with the petition or subsequently, but we can definitely include that in our Q&A answer document, because I'm not too sure if it's like a specific form or if you just submit a request. So I will make sure that we look into that.
Thank you. Next question is, if you move to another state, does guardianship follow you, or do you have to reapply for that state?
So I think I covered this, but just to reiterate, in North Carolina, you do have to submit a form for a transfer. So it won't follow you automatically, but there is a form. It's on the North Carolina courts website. to request a transfer. And I think that's both for counties and states. So if you're moving counties, because it is the county court that puts the guardianship in place, you do have to apply for that transfer. But you don't have to reapply, go through the whole process again in a new state or county.
Thank you. And I see a lot of questions around getting a recording of this webinar. So yes, we are recording this webinar, and a follow-up email will be sent either later on this afternoon or early next week that will have a link to the recording, a copy of the slides, and a certificate of participation. Next question is, what is the typical cost of an MDE?
Yeah, so when we did the research, we didn't see a typical cost. We just saw who would pay for it, but I'm happy to look into that as well, or see if there is any typical cost. It might be different depending on the valuations, but we'll look into that.
If you have general guardianship over a ward, in parentheses, she put her daughter, can you move someday out of state? What happens with guardianship if you move out of state? I think you just answered this one. Let's see. How does a potential ward acquire a public guardian?
I do know that there are agencies that provide guardians for guardianship if it's not going to be someone in the family or a family friend. So, I mean, the process for establishing the guardianship is going to be the same. We can do more research on the actual process, but generally you want to find an agency that provides public guardians. And I believe we had one or two that do offer guardians in the resources page that we just had, but we can provide more information on the process and how it differs when you're looking at a public guardian instead of like a family member or a friend.
Yeah, thank you. And I believe that local departments of social services, DSS, if you call, should also contract with different organizations and agencies that can provide that service. So there could be a good resource to reach out to as well. Okay, this is a good question. Can guardian of a person apply for Medicaid or food stamps for the ward, having pushback from some agencies in selected counties not to allow?
I did not come across this. I would assume so, based on the legal rights that are, or the legal control for guardian of person. There may be some issue. I don't know that would be considered financial. I can't imagine that you would have to be the guardian of a state for something like that, since it is a government benefit. But that may be part of it. But we will absolutely look into that more specifically, since we didn't come across that specific issue, in our research.
Okay. Oops. What if the biological parents are both disabled and get Social Security disability income, so they aren't required to provide any kind of child support? I'm the legal guardian of a 13-year-old child, and we've never received any kind of child support, and we are financially responsible for her. And I think that question popped up shortly after you talked about guardians not being financially responsible for the wards, but I think that's a different context, possibly.
Yeah, so in adult guardianships, a guardian is not expected to be financially responsible for the ward. I believe with guardianships of a minor, you may be expected to be financially responsible. Our research was focused on adult guardianships, so we don't have as much context for guardianships of a minor, but we're happy to look into that and see if we can get some more information, if there are any like governmental benefits for minors with disabled parents who have a different guardian. But again, our research was focused on adult guardianships.
Is there a checklist, guideline, evaluation tool for at what point someone impaired by disease is no longer just making poor decisions, but demonstrating incapacity or incapacitation?
So as we saw in the MDE, this is very multifactored and really dependent on the situation. There's no checklist. It's not like if you do XYZ or you have XYZ condition that you're automatically legally incompetent or need a guardian. So it's very multifaceted, and you would probably want to look at the factors that we pointed out in this slideshow. But yeah, there's no specific checklist, but I'm happy to when we send out this slide to show. There was a document that we were looking at about MDEs that really explained how the medical evaluation process happens, and we're happy to attach that as well.
Next question is, are they able to have a trust that's already established before guardianship?
So yes, if you have a guardian of a state, that person will become responsible for managing the trust. And a guardian or general guardian, because they are also responsible for the financial ownership. If you have a guardian of person, they won't be responsible for it. But if there is a trust that's established before the guardianship, it can still be present. The point of a guardianship is not to take away any financial assets or anything. So you can have that. And we talked about the special needs trust, and that would fall into that category.
Thank you. Are all North Carolina guardianship cases permanent until modified later, or do courts offer temporary guardianship status?
I'm not sure about temporary guardianship status, but all guardianships are permanent when they are put into place. The only way to modify or change them is to go through the process with the court. If you're wanting a temporary status, I would look into something like power of attorney, because you can set a temporary date for that, but guardianship is a permanent thing.
You may have answered this, but can a guardian live in a state that is not the one in which the ward lives?
I don't believe I actually answered that specific question, and I will need to look into that more specifically. I know we can move the guardianship itself, but I'm not sure about cross-county or cross-state guardianships. We did discuss that if a guardianship doesn't, or if a guardian doesn't live in North Carolina, they will have to submit to North Carolina jurisdiction, but they may be able to live in a different state as long as they're willing to be subject to North Carolina jurisdiction.
Thank you. Next question is, will you be talking about foster infants or children who are in custody of DSS who are being placed in guardianship with a non-family member?
Again, our research was focused on adult guardianships, not the guardianship of a minor. They are pretty different things as far as I can tell. So unfortunately, we did not do much research on foster care or DSS custody or anything like that.
Yeah, thank you. Yeah, so we asked them to specifically do research on guardianship for children and youth with disabilities that were turning 18. Can a person with a supported decision-making agreement or POA be a general guardian for someone else? And then in parentheses, the word siblings with a question mark.
That is something we'll have to do some more research on. I don't know the answer. I do know that it would be taken into consideration when choosing the guardian, because you're looking at the best interest, and a clerk may weigh that as a negative factor if somebody needs the assistance making decisions to put them in charge of someone else's decisions. But that doesn't mean that it's necessarily out of the question, but we will do some more research on that and put it in that Q&A document.
Good questions. That's why I knew we needed to save the chat. I knew the good ones were going to come.
Yeah, and I just wanted to add something to that. So the only like 100% like right that the person under the guardianship loses is they cannot be the guardian of incapacitated adults. So like if those siblings were adults, that's for sure out of the question. But like Emma said, we didn't research like specifically siblings, for example. And also, I just did research on the temporary guardianship question. I wanted to make sure I felt like I had seen something on that. So it does look like you can do something called an interim guardianship, like a temporary guardianship, but it's usually reserved for like emergency situations. Like this person needs a guardian today because there's reasonable risk of harm, or they're like in a lawsuit and they need someone to represent them because they're not competent. And usually those become full-term guardianship. So still not sure if there's like an ability to do a temporary guardianship and it not become full-term, but it does look like temporary guardianship is contemplated and can exist. And I just wanted to add that in.
Thank you. Thank you, Evelyn. Next question. My son already receives SSI and I am his representative payee. Do I need to establish guardianship to continue to be his representative payee?
Yeah, so I believe I answered this, but I'll just restate it. You do not need to be a guardian to be a representative payee. It was listed under alternatives. So if that's your only concern, you can just do that. I don't know if you'll have to, I don't know if he's a minor right now. I don't know if you'll have to reapply once he reaches the age of majority. You may have to, because often once you reach the age of majority, all of the legal things transfer over to that person. But you don't have to be a guardian. You don't have to have that full level of control to be a representative payee.
Thank you, Emma. All right, we got about 3 more minutes left. We're going to squeeze in as many as we can. And then the rest we will create that Q&A document and send out. I actually am going to take just a second to launch a quick evaluation poll. I almost forgot. So you should see it. Some folks who might be using a phone to participate may not see the poll. But we are funded largely by grants and we collect this data to report back to our funders. So it would be incredibly helpful if you guys could fill out this short evaluation poll for us. We will go over your feedback and definitely utilize that. Thank you so much. Okay, we can continue with Q&A. Another good question, are there any resources for how to have conversations with someone who is intellectually disabled about the options?
I would look at those resources that we have at the end of the PowerPoint. They do have a lot of really wonderful information and guides about deciding on guardianship, and we'll likely have some information about having those conversations.
Next question, if general power of attorney covers so much, why attain general guardianship if you can just get general power of attorney? Does a general power of attorney have the same legality as general guardianship?
Yeah, so this is why we presented it as an alternative. For some people's needs, it may be sufficient, but one very important thing that I mentioned is that the person has to be competent to either sign the power of attorney or to give the authority to someone else to sign it. So if they're already like deemed legally incompetent by, let's say, a physician, then the power of attorney would not be a valid document to begin with. So you would, if you wanted like the same types of control and ability to make decisions for that person, then you would probably want to pursue a guardianship or another one of the alternatives that we mentioned. Also, but also the power of attorney itself has some limitations, but those types of limitations are also potentially present in a guardianship. For example, you can't make a power of attorney to have someone let you get married. I know that's a very weird one, but you know, it's just an example. Like you can't make a power of attorney for marriage, because you yourself need to understand and be able to consent to the marriage. So there are some limitations on the power of attorney document, but they are both legal. They both have the same legal weight, let's say, but they do different things. And the power of attorney could be limited depending on the way that you word it. And versus a guardianship is like a ongoing relationship, and a power of attorney is the person that's making the decisions has to follow the scope, has to follow the words of the power of attorney. So like if the power of attorney doesn't say anything about, let's say, picking where the person lives, and it doesn't fall under the scope or doesn't fall under the language, then they might not be able to do that. Versus a guardianship of the person, it's kind of assumed that they'll have that power. So there are some differences, and they're important differences, but it's very dependent on your situation, and that's why there are alternatives that you need to weigh.
All right. Unfortunately, we are at time, and there are lots of thank yous in the chat. Great information, great presentation. These ladies did a lot of hard work to put this together. So we want to thank them so much for doing this. We truly, truly appreciate it. There are lots more questions in the chat, and we recognize that. We are going to save those, and we are going to take some time to go through those, do some research, and try to get all the questions answered to the best of our ability. And so I'm going to definitely say that the follow-up email will not go out this afternoon because there's a lot of work to do. So hopefully we can get that to you sometime next week. And if the Q&A document needs to come a little bit later, we can do that too. So thank you all so much for joining us today. Thank you so much to our interpreters, Angie at Full Circle Interpreting. We appreciate you so much for making this webinar more accessible to people who speak Spanish, and Emma and Evelyn, 2 E's. Thank you so much for all your hard work. Great presentation. Thank you so, so much.